Good morning. Yes, I am today. I am going to discuss with the judgment, which will be helpful for you. You want to learn much subject, particularly those who are preparing for district judges examinations, district municipal examination. This is AAR 2024 Kerala 149. AAR 2024 Kerala 149. It was this second appeal was filed with MA Satar versus Thiruvananthapuram Citizen Protection Forum, registered under Charitable Scientific Cultural Society, Thiruvananthapuram. Actually, there was a port, historical port, and next to the historical port, somebody was having some building, and they seems to have constructed a wall and superstructure and annexing the port wall as their own wall. So therefore a suit was filed, mandatory injunction, impeding authorities as well as the private parties, seeking mandatory as well as permanent injunction. Actually what had happened, Palavangadi Port is adjacent to Sri Mahaganapati Temple at Palavangadi. It is within the city of Trivandrum district. According to Kerala Ancient Monuments and Archaeological Sites and Remains Act 1958, any injury caused to ancient port is a cognizable offence. Then they have also said the seventh defendant violated building rules and constructed, so it should be liable to be demolished. So lower court has dismissed the suit after proving 7 issues. There was no satisfactory evidence that defendant has affected any authorized construct or tampering with the ancient monument. But first appellate court set aside that, and apart from mandatory injunction and taking action against the seventh defendant, there was an agreement, that is Kuttappa Pattam lease. There was no pleadings for a mandatory injunction was granted in the appeal. There was no pleading, no issues, no opportunity to the seventh defendant. Therefore, that area of the degree passed by the appellate court was set aside, and the government was given liberty to take appropriate action in accordance with law to give the prayer for Kuttapattam, that is called, they say, Kuttakapattam, that is something lease agreement. Therefore, somewhat assignment lease. Therefore, this is what I want. Why I am discussing this judgment with you? Paragraph 14, the appellate judgment of the law was challenged for second appeal. You can see, as the first appellate court committed an illegality when it granted relief of mandatory injunction to the government to resume the land given on Kuttakapattam to defendant 7, where the violation of condition was not at all an issue. That is possible. If it was not issue, therefore granting relief is illegal. Then the question also kindly follow this. First appellate court drawn necessary inferences and presumption based on the pleadings and evidence. So, according to the Supreme Court, the appellate court did not draw inferences and presumption on pleadings and evidence. Therefore, they set aside the judgment. Several Supreme Court judgments were deeply discussed at paragraph 27 to 31. Under what circumstances the degree passed by the lower court to be liable to be set aside? If there was no issues, there was no opportunity for the defendant, no evidence. So, for those who want to know much about the second appeal and substantial question of law, this judgment would help you. That is my endeavor. This is AIR 2024 Kerala 149 MA Satar versus Thiruvananthapuram Citizen Protection Forum, registered under Charitable and Scientific Cultural Society, Thiruvananthapuram. Best wishes.